Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2 of Jefferson County, Texas. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to this court today because you have a case in this court. You have a criminal case in this court, and criminal cases are divided into felonies and misdemeanors. We handle misdemeanor cases in this court. If you had a felony case, they will be handled in the district court, which is right down the hall. Now, as I said earlier, felonies are divided into misdemeanors. Well, criminal cases are divided into misdemeanors and felonies. Your felony case, hold on a minute. As I said earlier, criminal cases are divided into felonies and misdemeanors. Your felony cases are handled in the district court. And if you had a felony case, felonies are divided into 5 categories. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and state jail. Now, if you have a state jail felony, the range of punishment is 6 months to 2 years in the state jail, fine up to $10,000. If you had a third-degree felony, the range of punishment is 2 to 10 years in the state penitentiary, fine up to $10,000. If you had a second-degree felony, the range of punishment is 2 to 20 years and a fine up to $10,000. If you have a first-degree felony, the range of punishment is 5 to 99 years to life in the state penitentiary and a fine up to $10,000. If you have a capital murder case, the range of punishment is life or death. Now, for the misdemeanor cases, misdemeanors are commonly referred to as your petty offenses. That doesn't mean that they are not serious as a felony, it just is not as serious as a felony. Now, for the misdemeanor cases, misdemeanors are divided into 3 categories. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. The Class C misdemeanor is the lowest misdemeanor, and the Class C misdemeanors are normally handled in the city court or the municipal court, or the JP court, which is commonly referred to as the Justice of Peace Court. The range of punishment for a Class C misdemeanor is fine only. You cannot get any jail time. You only can be given a fine for Class C misdemeanors. Now, we do handle Class C misdemeanors in county court when they are appealed from the JP court or the city court. So once the person is found guilty of a Class C misdemeanor in the JP court or the municipal court, if they file an appeal, then the case comes to county court at law. And then we'll have jurisdiction over those cases, but the range of punishment will still be the same, a fine only. The next highest misdemeanor is a Class B misdemeanor. The Class B misdemeanor, the range of punishment is anywhere from 0 days to 180 days, which is 6 months in the Jefferson County Jail, and or a fine from $0 to $2,000. The highest misdemeanor we have is a Class A misdemeanor, and the range of punishment for a Class A misdemeanor is 0 days to 365 days, which is a year in the county jail, and or a fine from $0 to $4,000. Now, you have been asked to come here for an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning the case that you have. The first right that I will go over is your right to have an attorney. On that clipboard that you have, the first sheet is titled Judge's Explanation of Rights to Defendant Without Attorney. And it says that as a defendant in a criminal case, you have three options. Now, the three options are regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Number three, you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor. Now, the prosecutor is the assistant district attorney that works for the DA's office. You may not speak to the prosecutor about your case unless you sign a written waiver. Now, what a waiver is, you have, as I stated earlier, you have a right to have an attorney. You also have a right to waive, which means to give up your right to have an attorney. So if you sign a written waiver of your right to be represented by an attorney, then you'll be allowed to speak to a prosecutor about your case. Be aware there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, it states, the defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in this case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right, which means I want to give up my right to an attorney and represent myself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that's titled defendant. And then you will write today's date on the line that's titled date. And today's date is June 21st of 2022. Now, for those of you individuals who will be waiving your right to an attorney and representing yourself, you will have to read and sign the second page that's on the clipboard. The second page is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 21st day of June of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, then you will sign on the line right above the word defendant. You put your signature there, and above the line that's titled date, you will date it today's date, June 21st of 2022. Now, as a defendant in a criminal case, you have additional rights. Another right that you have a right to have a trial by jury. And what a trial by jury is where this young lady is sitting in that area. We call that the jury box. 6 citizens will be selected to sit on your jury, and they will decide after listening to all of the evidence and deliberating whether or not you are guilty or not guilty. You also have a right to waive your right to have a trial by jury. And waiving your right to have a trial by jury means that you are giving up your right to have a trial by jury. And by doing so, your case will come before this court or this judge in one of 3 ways. One way it could come before the court is by way of a bench trial. What a bench trial is a trial before a judge only. You don't have a jury. The case is going to be tried before the judge. And the judge will listen to the evidence. And after listening to the evidence, the judge will decide whether or not you're guilty or not guilty. If the judge finds you guilty, then the judge will also assess the punishment. Now, your case can come before the judge another way. The second way it can come before the judge is by way of a plea bargain. It can come before the judge by way of what we call an agreed plea bargain. What a plea bargain is, it's a settlement that you and the state have reached on your case. Y'all have reached a settlement. For example, let's say if you're represented by an attorney, your attorney will talk to the prosecutor, or if you representing yourself, you will talk to the prosecutor. And if you are able to settle your case, we call that a plea bargain agreement. That case will come before the judge, and the judge will decide whether or not to follow the plea bargain agreement. If the judge does not follow the agreement that you have reached with the state, then you could withdraw your plea, which means you can take your plea back. For example, let's say you enter a plea of guilty or no contest, and y'all have reached a settlement. And let's say the state has said, okay, 2 days in jail, and you said, okay, I will accept that. And it comes before the judge, and the judge said, well, I'm not going to follow that agreement. So if the judge doesn't follow the agreement, then you can take your plea back. You don't have to go forward with it. Now, if the judge does follow the plea bargain agreement, then if you decide within 30 days that you would like to appeal your case, they have a higher court to look at it, then you have to get the judge's permission to appeal your case to have a higher court to look at it, because the judge followed the agreed plea bargain. Now, the next way your case can come before the court or before the judge is by way of an unagreed plea bargain. And what that means is you want to enter a plea of guilty, no contest, and you and the state have not been able to reach an agreement. Let's say the state is saying, okay, I'm offering you a year in the county jail. And you say, well, I don't want that. I still want to enter a plea. I want the judge to decide what my punishment is. And so we call that an unagreed plea bargain. Okay. So as I said earlier, you have a right to have a jury trial. However, if you waive the right to have a jury trial, your case can come before the judge by way of an agreed plea bargain. It could come before the judge by way of an unagreed plea bargain, or it could come before the judge by way of a bench trial. Now, you also have a right to have witnesses to come to court. And witnesses sit in that chair over there. We call that chair the witness stand. And what witnesses do, they can testify. They can testify either for you or against you. If you representing yourself, you can ask some questions. If you have an attorney, your attorney can ask some questions. We call it, when you're asking questions, it's either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. In essence, you have a right not to call any witnesses. Now, just because you're not calling witnesses does not mean the state will not be calling witnesses. Okay, it's their case, they'll be calling witnesses. Now, you also have a right against, you have a Fifth Amendment right against self-incrimination. And what that simply means is you have a right not to testify in your case. And the state cannot force you to testify. When I say the state, I'm talking about the district attorney. They can't force you to say, okay, you take the witness stand and tell us what happened. They can't force you to testify if you invoke or if you say you would like to stand on your Fifth Amendment right not to testify. Now, you can waive or give up your Fifth Amendment right not to testify, your Fifth Amendment right against self-incrimination. And by doing so, you will be taking a stand. Okay, you'll be waiving it or giving it up. And so you will be taking a witness stand to testify in your case. You also have a right to have what we call discovery. Discovery means you have a right to see the evidence or have access to the evidence that the state has against you. For example, let's say the state has a video, or they have witness statements, or they have documents, or they have some objects that they found maybe with some fingerprints on it or whatever. You have a right to have access to that. If you're represented by an attorney, your attorney will have access to it. We call that discovery. Now, you also have a right to waive discovery, which means you have a right to give up your right to have discovery. And by doing so, you will not be having access to the evidence that the state or the district attorney's office has in your case. Now, everyone here, you're here, you've been arrested and you're out on bond on your case. You're either out on a PR bond, we call that a personal recognizance bond, or you're out on a cash bond. In essence, you paid the full amount of the bond, or you are out on what is called a surety bond, which means that you paid a bondsman a percentage of the bond to get out. Now, every day that you have spent in jail, you can get credit on that time toward your sentence. So for example, if you spent 5 days in jail and you're in the state of negotiating and the state is offering to settle your case for 5 days in jail, that simply means that you will not have to spend any more time in jail because you've already spent 5 days in jail. So you'll get what is called credit for time served. Now, if they are offering you 7 days in jail and you spent 5 days in jail, that just simply means you have to do 2 more days in jail, okay? Because you get credit for the 5 that you already spent in jail. Every day that you spent in jail count as $100 toward your fine and court costs. So if you spent 5 days in jail, that's $500 that can go toward your fine and court costs. So for example, if the state is offering you a fine and court cost of $500, that means you won't have to pay the $500. Why? Because you spent 5 days in jail, and 5 days in jail is $500 that will be credited towards your fine and court costs. Now, if they are offering you fine and court costs of $700, that simply means that you would have to pay $200 because you've already got credit for $500. Now, if you cannot pay the $200 on the day that your case is disposed of, then you could be put on what is called a payment plan. You could pay it off in installments, in monthly installments. But let's say, even if they put you on a payment plan, you don't have money, you still will not be able to pay it off. Well, no problem, because the law allows the court to convert your fine and court costs to community service. So, for example, I used the $200, you had $700 fine and court costs, you did 5 days in jail, so you have to pay $200. And so what we can do is we convert your $200 to community service. And so every 1 hour of community service that you do, you get $12.50 that will go toward your fine and court costs. And what that basically, what is translated into is basically, if you work 8 hours one day, that's $100, okay? So basically, if you work 2 days, eight hours a day, that's $200 would pay off your fine and court costs. And your community service is done at a local nonprofit organization. Now, also, Jefferson County has a program. When I say Jefferson County, I'm talking about the DA's office. They have a program that is called pretrial diversion. Pretrial diversion is for people who have never been in trouble before. You're a first time offender. So what that program entails is they will dismiss your case and you can get it expunged, deleted, wiped off, erased. Expunged means to delete, erase, or wiped off from your criminal record. Now, in order to get into the program, as I said earlier, it has to be your first case. It cannot be a case involving unlawful carrying a weapon or resisting arrest. You have to get an attorney to help you do the paperwork to get into the program. And once you get into the program, the case is dismissed. And once you complete the program, you can get it erased, deleted, or wiped off from your record, which means you can get it expunged from your criminal record. If you are a veteran of any one of the branches of the United States military, the district attorney's office also has a program that is called Veterans Court. Veterans Court is part of the pretrial diversion program, which means you get into the program, complete the program, case is dismissed, you can get it erased, deleted, or wiped off from your record. Now, for Veterans Court, I think the only criteria is that you have to be a veteran. I don't think they have a criteria of the type of case that's involved. And so with that, if you're a veteran, you may qualify for Veterans Court. Now, this court, Jefferson County Court at Law Number 2, also have a program that was started by me within the first 100 days of taking office in March of 2017. That program is called the Community Safety Initiative, short, we are commonly referred to as the CSI program. And with that program, the program is designed to address the issue of recidivism. Recidivism just is basically means people commit crimes over and over. So how do we address that? Well, we address it through our CSI program. And with the CSI program, we have partnerships with local agencies. We have a partnership with our local mental health agency, the Spindletop Center. Spindletop, they will do a private interview, develop an assessment plan, and also develop a treatment plan, either outpatient or inpatient. Now, you do not have to be insane or incompetent to participate in the program. If you suffer from any type of mental illness, such as being bipolar, schizophrenic, depression, anxiety, post-traumatic stress, ADD, ADHD, or any type of mental illness, then Spindletop will be able to address those issues. If you have an issue or have a problem with drugs or alcohol, drug or alcohol addiction, then Spindletop also has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. And we also have a partnership with our local Drug and Abuse Council. They have a program that is called OZAR. OZAR stands for Outreach, Screening, and Assessment Referral. Both programs are programs where they will do a screening, which is basically an interview. They'll do an assessment. Once they do an assessment, and then OZAR can refer you for either outpatient or inpatient treatment, and Spindletop can do the same thing, outpatient or inpatient treatment. If you are unemployed or you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you select one of the areas that you would like to get trained in, you'll be placed in the program, and once you finish the program, they will assist you at getting employment in the area that you are trained in. If you have not finished high school and you would like to get your high school diploma, the CICE program has a GED program, which means you could get your high school equivalency, your graduate equivalent diploma through that program. Now, all of these programs that I've just mentioned to you do not cost you anything. They're free. Only thing you have to do is have a desire to be in one of the programs. And if you have a desire to be in one of the programs, then they will be able to, you'll be able to be assisted at getting into the program. And I tell people this all the time. In county court at law number 2, we do not just have court as usual, we have unusual court. And the reason why I say that is because not because we are different, but because we're trying to make a difference in the lives of the individuals that come before this court. And we're trying to make a difference in Jefferson County, the county in which we live, by making Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. Also, county court at law number 2, we do not just give time, we take our time. And we do not just arrest the problem, we address the problem. So whatever problem that you have, we will address those problems. And we believe by addressing the problem, we can produce productive people. And we believe that producing productive people is beneficial for our county, because productive people, for the most part, do not commit crimes. Why? Because they have too much to lose. And so if you're interested in any one of these programs, just let us know. We have some brochures. Also, we have Sarah Henderson. She's with Spindletop, and Sarah is going to come forward and tell you what Spindletop has to offer through our CSI program. At this time, Sarah, you are.
One put forward in the flyer in Spindletop Farm, and at the very least, I want to give you that it has our crisis number on it. And it's a 1-800 number if you ever feel that you were in a place, you can contact us with that number. Spindletop is here today to provide you with support. Like the judge said, it's to help you, not to condemn you for any disability or mental health issue that you may have. You're welcome to speak to me privately. On your demographic sheet, that is the last page in your packet. If you would like to speak with me privately today, or if you would like me to call you today, you can just check that you would like other resources on that information. So if you have any questions, I will be available when you go into recess. Thank you.
Thanks a lot, Sarah. Now, ladies and gentlemen, the paperwork that you have, we have court personnel who's here to assist you with filling out the paperwork that you have on your clipboard. We're going to take a recess at this time to give you time to do that. Now, if you need to go into the hall to go to the restroom, you can do that. And the restrooms are, I guess, to my right outside the door. The men's restroom is on this side, the hall. The female restroom is on the other side of the hall. Now, do not leave the building, because you're here for court, and if you leave the building before your case is completed, your bond may be forfeited. And if your bond is forfeited, that means that a warrant will be issued for your arrest. So this shouldn't take us that long to do what we need to do. So at this time, we're gonna be in recess, give you time to fill out the paperwork, and if you need some assistance, we have core personnel here to help you with that paperwork. And then once we get the paperwork from you, we're gonna call you up before the bench. There's an X here in front of the bench. We're gonna call you up one at a time. And once we call you up one at a time, then we will dispose of your case or reset your case, and then you'll be free to go, okay? So at this time, the court will be in recess.